This video is made possible by Practical Defense Systems, the best online security training at the lowest prices. You can start your security career today online at pdsclasses.com. Check them out. Hi, I'm Joel Persinger. I'm the Gun Guy. Thank you very much for all of your support of GunGuyTV. Please continue to watch and like and subscribe and share and all that kind of stuff. And if you would please follow me on these two platforms as well, because the truth is that YouTube shadow bans the snot out of me, and Rumble and X do not. So I'm really trying to grow the followings on those two places. Rumble is outstanding if you're just looking for the videos. X, if you want to listen to me blather on about political things, you can go over there because we'll post the videos in that. The other thing about X is I also post all the videos from the Practical Defense Systems channel, which are more training related. So if you want to go to that, you want to see that kind of stuff, go to the Practical Defense Systems channel. There's a link in the description. That's where I do most of those things. All right, we're going to talk to Chuck Michel today. Chuck is the volunteer president of the California Rifle and Pistol Association. He also runs the Second Amendment Law Center, and he is the founding partner of Michel and Associates and a constitutional attorney. So he's a good guy to talk about this stuff. There's a whole lot of stuff going on in the courts right now, including the NRA case. They just won a good victory toward actually getting some money back, which is always good. There's the Rahimi case we'll get information on here pretty soon, and several others. Let's go talk to Chuck. Chuck, thank you very much for joining me again. I'm super grateful. I know you guys are incredibly busy. There's a lot going on in the country, a lot going on in the world we could talk about, but I think we probably ought to focus on the Second Amendment. I know we both have opinions. I certainly have opined on social media already about the whole court case with Trump and like that. But what's going on with the Second Amendment? I know we have Rahimi coming up. I know that the NRA, God bless them, had a pretty solid First Amendment victory the other day. What shall we talk about?
Well, let's talk about Vulo, the NRA case, and then Cargill, the bump stock case. So that's a First Amendment case and an administrative procedures law case. And then we can talk about Rahimi, the Second Amendment case that's there's going to be a decision on. So in Vulo, that was the NRA's case against certain New York officials because they basically threatened mostly insurance companies and banks that were doing business with NRA. They said, if you keep doing business with the NRA, you're at risk of us coming in and inspecting you and, potentially taking action against you. So they were threatening these companies to disassociate with the NRA unless they wanted to risk regulatory action against them. And that the Second Circuit said that's okay. It's just an opinion. It's not coercion. But the Supreme Court 9-0, Justice Sotomayor wrote the opinion, said no. The NRA has given enough evidence to indicate that this was coercion. There were press releases that said companies should be careful and they're risking regulatory action against them if they don't disassociate. So there was clear evidence that this was more than just a government official expressing an opinion, which they can do, but to throw the weight of the state, the government, behind their desire to silence a political group that has speech that they don't like, pro-gun, pro-Second Amendment, pro-freedom, whatever, and threaten regulatory action to silence that. The Supreme Court thankfully shut that down. Interestingly enough, the Supreme Court was represented by the ACLU.
Yeah, I was going to say it's interesting because, first of all, I found interesting that it was a 9-0 unanimous victory, and Sotomayor, however you say her name, is the one that wrote the opinion. She's no friend of the Second Amendment in particular or gun owners. How significant is it when a very sharply divided court makes a unanimous decision like that?
Well, it's very significant in the First Amendment world. It's not particularly, you're never going to get this in the Second Amendment world, but this wasn't a Second Amendment case. This was a free speech case and the efforts of government officials to silence the NRA speech. So it's significant in the sense that it really clarified that governments can't threaten related entities in order to silence a disfavored group's speech. And the ACLU even said that. They said, there's lots of less powerful groups than the NRA out there, and there are conservative government officials who would love to silence them. So if the liberal government officials can get away with it against a conservative cause like the NRA, that's just license for conservative politicians to use it against liberal groups. So that's why the ACL could stomach getting involved. They would never get involved in a Second Amendment case. They're hypocrites on the Second Amendment. But as far as the First Amendment is concerned, it's a total different body of law, a total different area of jurisprudence. And so it's not as surprising that you'd get a unanimous decision when it comes down to protecting First Amendment rights.
How does that affect us here in the People's Socialist Republic of California and like restrictive states when we're fighting for our Second Amendment rights as well as our First? Does this decision have an effect on us?
Nah, well, not unless some government official overreaches. And that's not impossible, particularly in city councils where they don't have the degree of legal advice being given to them. You're not going to hear Newsom. You're going to hear him criticize the NRA. He always does, but he's not going to reach out unless he's an idiot. Well, that's not foregone.
Don't get me started.
but he would have to. His lawyers are going to tell him, you can't threaten other business entities who are doing business with the NRA to stop doing business at risk of government sanction.
What else is going on? We've got Rahimi.
Okay, so you have Cargill.
Cargill, there you go.
We're waiting for that one. I expect that's a administrative law question, not a Second Amendment question. Again, it's a matter of whether or not any regulatory agency can just reinterpret its regulations. Tell people that something's legal, in this case, bump stocks, for years. People buy them, people have them, people use them. And then politics change. Somebody misused one of these things in the Las Vegas festival shooting. And because of that rat bastard, the NRA tried to change its, the ATF tried to change its regulation to turn bump stocks into coming under the definition of fully automatic machine gun. Now that is also a big problem, and it's also routine. Government agencies never cede power. Government lawyers never acknowledge that their agency is limited and can't do something. They're always on a quest for more power. And so the government is arguing that the ATF is free to change its mind, basically, and in the process criminalize tens or hundreds of thousands of people who have these, bought them legally based on NRA, on ATF's representation that they were legal. So it's a matter of interpreting what the regulation means and whether or not an agency's interpretation that changes is binding. And that applies, that comes up a lot in environmental cases. The EPA is inclined to change its regulations, unilaterally, the interpretation of its regulations when it doesn't like something. Tax collection agencies do this. It's a problem within the government. And that's one of the things that there's a related case that challenges the Chevron deference doctrine, which is where the courts generally give deference to the regulatory agency's own interpretation of a regulation, which, like I said, that they never interpreted against themselves. So why should the courts give that any special deference? And that's another case that I forget the name of it right now that will be coming down out of the Supreme Court this session. And those two cases could really change the game on how much government agencies can get away with when they're interpreting regulations or reinterpreting regulations because of politics.
We've just talked about now 3 cases, all of which are essentially dealing with regulatory agencies. U.S. citizens, we all suffer under the thumb of the fourth estate, if you want to call it that. It used to be considered the press, but actually I think it's the fourth branch of government that's unelected, regulatory agencies that just make decisions and enforce, that become effectively law, pell-mell without Congress. Is this the court, do you think, making the attempt to rein in those agencies to some degree?
I think so. Yes, I think they've gone too far. The pendulum has swung too far to the benefit of regulatory agencies, government agencies, basically bureaucrats, to say the law means whatever they say it means. And that's not something that's not the way it's supposed to work. Those are the non-Second Amendment cases. Then we've got the Rahimi case, which is pure Second Amendment, a guy with a TRO or a restraining order against him. Dangerous guy, almost certainly should not have access to firearms, that individual, but the federal law says that anyone with a restraining order, whether they're dangerous or not, whether they're violent or not, can't have a gun. And so Mr. Rahimi's lawyers, federal public defenders, challenged the constitutionality of that statute. Now, the court made it clear in oral argument that they telegraphed that they're going to interpret this case narrowly. They're going to do an as-applied challenge to the constitutionality of the federal law, and that means they're going to figure out whether or not it's constitutional as applied to this individual, Mr. Rahimi, not whether or not the government condemn an entire class of people based on perhaps violence being demonstrated by some of the members of that class. And this is an important case, too, because if the government can classify any group of people that it wants as prohibited, then, in the past, they've done it to Catholics, they've done it to Native American Indians, they've done it to slaves and freed slaves. They could do it against MAGA supporters or patriots or, people who
former presidents of the United States. He just got convicted of a felony. That'll make this case sort of interesting. So now you got a guy who has Secret Service protection. He's surrounded by law enforcement carrying guns all the time, everywhere he goes. But he's not only not supposed to be in possession of a firearm, he's not supposed to be in their reasonable proximity. I mean, what do you do about that?
Well, right? we may see. We just got a decision out of the Ninth Circuit that you said you can't bar non-violent felons from possessing firearms, and now you've got President. I mean, I wouldn't be surprised if we saw that as part of his appeal or a separate case. Challenging the constitutionality of the ban on firearms by nonviolent felons. And don't forget, there's also the cannabis ban. If you smoke marijuana, you can't own a gun.
Right, which of course is nonsense. I mean, you might as well say if you drink a glass of whiskey every once in a while, or you drink a beer, you can't own a gun. It doesn't make any sense.
So this is the classification, and the progressives would love to classify all kinds of people. They'd love to demonize as many conservative political subgroups as they can and disarm them. So that the high stakes are high in that respect, but the stakes are even higher in Rahimi because the lower courts are playing so many games with the Bruin test and how it's supposed to be applied. And they are being led, by the way, by Everytown Law, Bloomberg's group of very, very well-regarded creative lawyers associated with big firms or on Bloomberg's payroll that are coming up with all these arguments that some lower courts are buying about how to distort and twist the Bruin ruling so that more courts can uphold more gun control laws, gun bans. So if the Rahimi case goes so far as to straighten out what the Bruin test really means, make it clear again that it's a two-step process, but not a two-step test. First, you decide whether or not the text of the Second Amendment covers the conduct or the arm, and that's a very, very broad coverage. Any bearable arm and armor, defensive arms. I mean, it's anything, almost everything.
Okay, so I want to define that term because we've mentioned it on the show many, many times. But somebody's going to say, "What does bearable arm mean?" When you talk about any bearable arm, that just means to me something I can pick up and walk around with.
Yeah, well, this
is that where that is, or is there? I mean, because there's a lot of things I can pick up, right? Okay, so there you go.
It's not completely. See, what the courts have tried to do is say that the class of, like, magazines aren't arms, so they're not covered. In Seventh Circuit, you've got a court of appeal saying that semi-automatics are too close to fully automatics, so they're not arms covered by the Second Amendment. What they're trying to do is push this stuff into the first question, whether or not the text covers the conduct, and so they can avoid having the burden shifted to the government, which is what happens in the true test, where they have to show that there are historical traditions and analog historical laws that show that the founders would have tolerated a modern day law, because how they regulated then and why they regulated it then is similar to how they're regulating it now and why they're regulating it.
Okay, so let me see if I can put a layperson's spin on this. So let's say that so we have two questions, and make sure I got it right. The right to keep and bear arms shall not be infringed, period. That text covers all bearable arms. So if it's a rifle, hang on a second. If it's a rifle, a shotgun, a pistol, a knife, a club, an RPG, whatever, if I can pick it up and walk down the street with it, hold on. If I can pick it up and walk down the street with it, that plain text covers that. But then we have to look at the second question of what is the historical tradition that may make it appropriate for the government to ban one or all of those based upon what our founders would have tolerated. And that's where an RPG may go away or whatever. Am I getting that right?
That's a good question. The RPG may not be a arm that's covered by the Second Amendment, and this hasn't been, there's no specific decision on
Although
this.
I really want one because I want to go blow up old trucks and like that out in the desert, but I know, you never know, right?
See, so the ones that are the arms that are indiscriminate, they go boom instead of bang. Grenades, RPGs, rocket launchers, whatever. Those are probably not the type of arms that are going to get covered by arms in the language of the Second Amendment. The big question is, what about fully automatics? Those are much more discriminate, but not, there's issues with how a fully auto fires, how it rises up and controlling it, and whether or not there's indiscriminacy. That's where there's some debate about where the line is drawn.
Well, and in our history, haven't we? I mean, I remember, and correct me if I'm wrong, Chuck, but I remember seeing ads in the Sears catalog and the Montgomery Ward's catalog and in old catalogs from back in the day when you could literally order a Thompson fully automatic and have it shipped to your house.
Yeah,
and you could order,
that was the Sears catalog.
Right, and that
was always on my Christmas list.
Me too. Whose is it not on? You could also, maybe Bloomberg. You could also order a BAR, because they were a popular military arm, and you could have it literally shipped to your door. So we have a history and tradition of fully automatic firearms being available to citizens.
Well, but then the question becomes, were they in common use, or are they dangerous and unusual? And there's, I think, 700,000 full autos in circulation overall, and that includes manufacturers, police. There's about 170,000 in civilian hands, mostly collectors. So is that common use? The dangerous thing here is, and this goes back to the Cargill case, if the ATF can reinterpret the regulation that bans full autos to cover bump stocks, the next step that the Bloomberg Everytown lawyers are going to be arguing is that they can interpret it to cover semi-autos.
Right.
So, and that's what the Seventh Circuit said. The semi-auto is too much like the full auto, so it can be banned. So there's still some parameters of this to be fleshed out, and I don't think Rahimi's going to address any of this directly. By the way, Second Amendment Law Center and CRPA just put in an amicus brief in a criminal case where a guy was challenging the constitutionality of the federal full auto ban, and we pointed out that that's a bearable arm. It's a bearable arm. You can't just say it's not a bearable arm covered by the Second Amendment. You have to go to the historical test, and that's why I say the way they're trying to twist Bruin is to make that first question, which is just supposed to be a pretty simple question, into another test. So it becomes a two-step test again. And the Supreme Court in Bruin said, hey, you've been applying a two-step test, and that's one step too many. So that's something that we hope the Rahimi case clarifies too.
Yeah, I should say the first part is not a test, it's just a question. because you don't even go to the test. If somebody wants to argue that carrying a frozen bag of squirrels is a bearable arm, then you don't even go to the question because obviously it's a frozen bag of squirrels.
Right.
And so there's I get what you're saying. So the actual test is simply the historical analysis. Do we have it?
Yes, that's the actual hurdle that the government has to get over. And they have the burden of proof. Isn't that the point? Because before Bruin, we had the burden of proof, but the Supreme Court turned that around, and now if it's a bearable arm and not a frozen bag of squirrels, then it's incumbent upon the government to prove that they actually have the authority based on the text, history, and tradition of the country in order to regulate. Based on the historical tradition. The text is the first part.
Oh, I'm sorry. The history
and
got
tradition
it.
Is the second part. So is there a historical tradition of banning an arm or regulating conduct similar to the conduct or the arm that's being regulated today that shows that the founders would have tolerated the modern day regulation? And that's almost always
and it's founders, not anti-gunners in 1965. It's the founders from 1791 in the surrounding area and maybe around where the 14th Amendment incorporated the Bill of Rights to the states.
And the reality is they almost never they went after specific bad people. If somebody did something bad, that individual could be disarmed. But they never went after a class of arms and completely banned them. They like to go back, and we've talked about this before, they like to go back to Bowie knives, where they regulated where Bowie knives could be carried and who could carry them, and some very specifically targeted laws on Bowie knives. But they never banned Bowie knives. They never said nobody could possess a Bowie knife, or a Bowie knife had to be registered, or any of this other stuff that they do with modern day gun bans. So it's a stretch. And if the Supreme Court in Rahimi clarifies what constitutes a good historical analog law that can be used to justify a modern day law, if they tighten that up, that's going to help us a lot in every case.
Well, what are the odds, do you think?
Well, I think we're going to win we're going to lose the battle.
Over Rahimi, but yeah, okay.
But I think we're going to win the war. Now, this is going to be very interesting because,
in other words, if I can put words in your mouth, Mr. Rahimi is a criminal, and they're probably not going to free up Mr. Rahimi, who's a violent criminal, to have guns. Yeah, but they may go clarify what we need them to clarify so that we can fight the battle in other places. Is that what you're saying?
Right. It's not the fact that he's a criminal. A lot of people, if you become a criminal by virtue of some conviction, then a lot of people are criminals. The question is, are they violent and dangerous? Or are they otherwise not? And if they are violent and dangerous, and Mr. Rahimi certainly seems to be, then they can be disarmed. But whether or not you
get some guy who's a white-collar criminal or somebody who's gotten arrested because he was smoking pot on federal law, that dude is not a violent criminal, right, and should not have his or her rights taken from them.
And there's no historical analog where people like that were disarmed. So it's always been dangerous people. And so, again, if Rahimi fleshes out the methodology, if Rahimi puts the brakes on the lower courts twisting Bruin, that would be good. Now, a couple things could happen, though. Remember, there are three Illinois semi-auto and magazine ban cases that have asked the Supreme Court to grant cert and hear them. And then there's Antonic out of New York, which is the sensitive places case where they try to make your CCW is not valid in basically any place where the public goes. And so that is in this, all those cases are lined up in the Supreme Court with a request that the court grant cert and review the lower court rulings. So depending on what they do in Rahimi, depending how broad that Rahimi decision is, they might grant cert in those cases and without hearing them, just vacate the lower court opinion and say, reconsider your ruling in light of what we just said in Rahimi. And that's what they did with a bunch of cases that were pending review in SCOTUS before Bruin came down. After Bruin came down, they said, well, reconsider everything that your ruling is vacated. Reconsider what your ruling in light of what Bruin says. And that's why Duncan and Rhodey and all these cases, Second Amendment cases, that went all the way up from the district court, many cases in front of Judge Benitez, up through the Ninth Circuit, where we won a couple, to the en banc panel, where the en banc panel ruled 7-4 that those laws were constitutional. That went up to the Supreme Court. Supreme Court said no, and it went all the way back down. So now they're working their way up again. So that.
And I guess the question is, does the Supreme Court ever get, I mean, I suppose they do. I would think, do the justices ever get to the point where they've just had enough? They do this, and then they send it back and say, reconsider it based upon what we just said. And the lower courts exercise, I've heard people say they call it judicial defiance. I'm going to call it judicial disobedience, where they just don't give a rat's behind, and they do what they darn well please. I mean, this cannot be allowed to continue. Is there ever a point where the Supreme Court just puts a stop to it?
Yes, but there are a lot of activist lower court judges, and in fact, CRPA Magazine is going to have a great article about the Ninth Circuit's en banc shenanigans and how certain judges basically don't respect the Supreme Court, like Reinhardt, the former Ninth Circuit judge. He basically said, when they asked him, well, aren't you contradicting Supreme Court's mandates? He said, well, they can't catch them all. It's like certain judges don't care. Some of these judges are mad that they didn't get on the Supreme Court and somebody else got on there instead of them. And, there's a lot of politics, internal politics and external shit. There's plenty of bias in the federal courts. Even worse in the state courts, and there was a perfect example yesterday. I think that they do get tired of it, and if they think they have the votes to straighten it out, they take action. The problem was after Heller, we had Justice Kennedy on there, so we think we had 4 votes, but we might not have had 5, so they couldn't take some of the. There was dozens of cases that asked the Supreme Court to review them, Second Amendment cases, before Bruen was finally accepted. And that only happened after the composition of the Supreme Court changed.
Does the law even matter anymore? We had, I hope that it does, but we just saw what happened with Donald Trump yesterday. And I look on social media, I hear it, I've said it, I feel it, that at some point the rule of law is gone in this country, and it doesn't matter anymore. And so if that's the case, what are we doing trying to fight it? And I guess that's where I hear the frustration in the voice of Americans, and I hear the frustration in the voice of gun owners, and I'm curious what your response is.
Well, this is the 4 boxes, help me out here. The soap box, the ballot box, the voting box, and the cartridge box, right?
Yeah, okay.
I think that's the 4 boxes.
And I've never heard that, so I didn't know, but it's excellent. I hope that's the 4 boxes because I kind of like it. But anyway, what's your point?
That we're not to the 4th box yet. And I hopefully never will be.
Well, and here's what concerns me. That yet is getting smaller and smaller and smaller. The more that this happens, we're getting closer and closer to that 4th box, and I think it's pretty frightening.
It is terrifying.
Yeah,
that's a no-win for everybody. But certain people are going to be very upset, and I think you're right. The Trump verdict kind of typifies this in a lot of people's minds. But some of these bad rulings on Second Amendment, there's different classes of people see different levels of injustice in different fields of law, and everyone's getting disillusioned. So yeah, it's the problem. But right now, we're still on the soapbox and the ballot box and the voting and the whatever the
court box, the voting box, whatever, the ballot box, the court box. So we're still working within the system, and we are very, very hopeful. And in fact, the odds are good that because of the way the Supreme Court is stacked, we will win. So there's no reason to give up hope yet. Let's see what happens with Rahimi. Let's see what happens with the other cases that are pending. Let's see what happens with Duncan, and then reassess. But you damn well better get out and vote. Chuck, thank you very much, man. Have a great week.
Always a pleasure, Joel. You too. We'll talk again soon.
You bet. Thank you again very much for watching the entire interview. I'm very grateful that you do that. Do like, subscribe, share, help me out here. Go over and visit me at Rumble and X. Again, Rumble's a great place for the videos. Both Practical Defense Systems and Gun Guy TV are both on Rumble. Likewise, you can go to X if you would like to see both of those in the same platform, and you get to listen to me ramble on and frustrate myself on political nonsense, all at the same time in the same place. You can also help me out and help me keep the lights on this, since obviously Gun Guy TV costs more than I make because it doesn't make any money, really. You can help me out with that if you'd like by joining Gun Guy TV Crew. You can do that by going to GunGuyTVCrew.org. GunGuyTVCrew.org, or you can go to Locals or Patreon and just look up Gun Guy TV. You'll find me on both of those platforms. Have a great week. Thank you very much for all of your support. Wherever you go, whatever you do, stay safe.